Good morning, my friends and followers. I'm your lawyer, Patrick McGinn, and I am your best friend at your worst time. We have late breaking news out of Dade and Broward County regarding the courts. We finally have temporary orders in place on how to deal with family law cases during this COVID thing going on here. Both Miami-Dade and Broward County chief judges issued orders yesterday. We'll go over Miami-Dade first. Miami-Dade yesterday, April 2nd, the chief judge issued administrative order 20-06 relating to parenting procedures in the family and unified courts during the COVID-19 pandemic. Let's get to the meat of the order. The order applies to all family law matters regarding parental responsibility and time sharing, to be utilized and complied with immediately in all existing and newly filed family division and unified children's court division cases in Miami-Dade County. So this applies to new cases as well as cases going on. The order remains in effect until a new order is put out. Does not preclude individual judge from modifying or amending this order in individual cases where the judge deems necessary. Any part of this order not changed by a subsequent order shall remain in effect. So what that means is this order stays in place unless the judge in your case issues an order, a newer order, or a contrary order based on a hearing or probably based on a hearing. All right, so what happens? Here it is. Contact with both parents and shared parenting. The court expects you to continue to adhere to all final judgments, temporary orders, settlement agreements, and other orders of the court awarding parental responsibility and time sharing. So whatever is in place in your case stands as it is right now. Regular time sharing is set forth in those parenting plans shall continue. This is how it relates to the regular time sharing and the summer time sharing along with school. Until the date, the regular time sharing that you have in place now during the school year remains in place until a school district or official governing the children's school announces the last day of school at which summertime time sharing will begin. So classes, if you're in a school district and they're having online classes and classes are still being conducted, you adhere to the regular time sharing. If they announce that classes are over, the school year has ended or whatever, you immediately go into the summer time sharing mode and follow what is your summer time sharing regime in your parenting plan in your particular case. All right, so if you were supposed to exchange the children or child at a school or daycare and that school or daycare is now closed, you have to make arrangements with the other party in writing by email, text, or parenting computer application, such as Talking Parents or Our Family Wizard. You have to make arrangements for another location. And the reason they want you to do that is they want those attempts documented in email, text, or through the application. And if you can't agree, you have to file a motion for the court. And let me tell you something, courts do not want to see these motions. They want you to be able to agree. They want you to be able to co-parent. These are extraordinary times, and they're going to call for extraordinary measures, extraordinary communication and understanding, and reasonability. This is not the time to take advantage of any other party in your case. If the governor of Florida or any other government officials issue a shelter-in-place order, which is not what we're under now. In Florida, we're under its stay-at-home orders, which means we can go out and still do essential stuff. But if they issue a shelter-in-place order where you can't leave the home, the parties and if they issue a shelter-in-place order to where no exchanges can take place, this is what's going to happen. The parties will abide by the directives applicable to their locality. Once the shelter-in-place orders are lifted, the parties are to resume time sharing as previously ordered in their parenting plan. Okay, for Miami-Dade County, in the event that the governor or other officials issues a shelter-in-place order which does not allow the exchange of children to take place, you stop exchanging the kids. Follow whatever rules are in your locality, and once the order is lifted, regular time sharing resumes as it would, whether it's summertime sharing or regular time sharing. And what they're going to do is they're going to issue makeup time sharing. For emergency motions and expedited hearings, the court can set those hearings as required and require the parties to appear remotely, which is probably going to be Zoom, since Miami-Dade County is up and running on Zoom. And it's cautioning people, and take this very seriously. Parents are strongly cautioned that unreasonable, hurtful, or destructive behavior may be sanctioned by the court in accordance with Chapter 61 of Florida statutes. And those are the family law and divorce statutes. So what they're telling you here is if you try to use this to take advantage in your case, they're going to end up hammering you. Okay. Communications. The court expects all parties to cooperate in the scheduling of telephonic or electronic hearings and when possible also depositions, mediations, and other out-of-court interactions, which basically opens us up, which we've been doing anyway. We did a deposition this week. I know people that have tried mediations. I personally haven't tried a mediation via teleconferencing, but we can go forward with that. And other out-of-court interactions, such as communications between parties and attorneys and stuff like that. And as usual, they require parties to speak to try to settle any motions prior to a hearing. And they want the requirement fulfilled by personal telephone calls or exchange of emails or text. Now, Miami-Dade has a special section related to self-represented parties. And just let me caution you a little bit about being self-represented in a family law case. About 98%, maybe more, of family law cases, divorce, paternity, etc., people are self-represented. And the courts know that, and the lawyers know that. But let me caution you with this. This is a very dangerous time to be self-represented because we're navigating uncharted waters here. So I would strongly advise you, if you can afford to hire a lawyer to navigate your case through these times. Anyway, they're telling self-represented parties you can obtain all forms from the Florida court's website. If you Google Florida family law forms, the #1 response is the state court's website where they have all the forms, and I'll put a link to that in the description or the comments below, depending upon where you are seeing this at. Self-represented parties will be governed by the same rules of law, procedure, and evidence that lawyers are required to follow. So if you're self-represented, they're going to treat you like a lawyer. They must file his or her pleadings with the clerk of the court in person or through the Florida court's e-filing portal. So if you don't have an account on the portal, you need to set one up. And if you go to, if you Google it, Florida e-filing portal, it'll come up to the site and it'll have directions on how to show you how to set up an account. Represented litigants would, after an emergency has been lifted, then be able to continue to use the portal for all pleadings. You've always been able, for quite a while now, you've always been able to open a portal account. They just didn't tell you. But you can open a portal account and you can file filings through it just like lawyers can. They're also telling self-represented clients to register with CourtMap in order to schedule and be apprised of hearings. CourtMap is a communications mechanism between the attorneys and judges. So now they're allowing, or they've always allowed, but now they're telling you to sign up for that so you can be apprised of all the hearings and stuff like that. Self-represented parties must immediately notify the clerk of the court and all other lawyers or parties in writing of any change of mailing address, telephone number, or email address. And keep in mind, in Florida, there is a relocation statute. So don't use this as an opportunity to take advantage and try to relocate someplace else in violation of that statute, because they're probably going to hammer you on that. Let's see what else comes from Miami-Dade County. Mission critical matters are moving forward that can be effectively done remotely without the necessity of in-person appearance in accordance with the 11th Judicial Circuit Administrative Order 20-05, which we have been doing already. There was an article that appeared, I think it was this morning or yesterday evening, where Miami-Dade has successfully completed a video conferencing hearing, their first video conferencing hearing in criminal court. And if you're interested, I'll post that in the description or the comments below. and you can read that for yourself. And it seems like they're going to be, at least Miami-Dade is going to be using Zoom, and supposedly all the judges are going through Zoom training this week. So next week we should start seeing regular hearings, at least on, and hopefully the Zoom platform will be able to keep up. I've been hearing, I haven't had any personally, but I've been hearing other lawyers say that the bandwidth on Zoom has been slowing down lately, and I'm guessing that's because everybody in the world is using Zoom. All right, on to Broward County. Broward County has a very similar order, and just for your information, if any of you are in Orlando has had an order in place for a couple weeks now, which is very similar to these orders. I read it about a week ago, and both orders are very similar in nature. Broward County order was signed by the Chief Judge also yesterday, and it's titled Administrative Order on Parenting in Domestic Relations Cases, which are divorce cases, domestic violence cases, paternity cases, anything that's going on in family court. In Broward County, this order applies to all family law matters, both newly filed domestic relations case in the 17th Judicial Circuit and current. It doesn't supersede or modify any existing domestic violence injunction, criminal no contact order, or dependency order which is in conflict with the provisions. So in those cases, whatever is in your case is the standing order. Administrative order stays in effect until further order by the court. Let's see. Pursuant to all current final judgment, temporary orders, settlement agreements, and other orders of the court awarding parental responsibility or time sharing, continue to be in adherence to all orders by all parties is expected. So whatever time sharing and parental responsibility orders are in place in your case are to remain and be respected and followed. Let's see. Unreasonably restricting access to the children of other parties. They're not going to like that. They're going to. This is what the courts are looking for at this time. Any court, any family law court in the state of Florida, they're going to look for you to be reasonable. If you are not reasonable, they're probably going to hammer you. All right, summertime sharing in Broward County. Pretty much the same as it was in Dade. Regular time sharing continues until the last day of school is designated in the parenting plan. If the school has ended for the 2019-2020 school year prior to the date designated in the parenting plan, the parties shall continue regular time sharing as though school were still in session until the designated last date in the 1920 official school calendar. Then summertime sharing begins as set forth in the parenting plan. So you continue in Broward County, you continue until the date in the parenting plan. Exchanges of the child, if you can't do it at the school, if the school or daycare is not currently open, you should make other arrangements in writing via email, text, or parenting app. If you can't agree upon a place, you shall use the nearest police station or sheriff's office that is located closest to the school or daycare. Now this is Broward County. Dade County is different. The closest police or sheriff station shall be determined by the distance shown on Google Maps, Apple Maps, or some other similar mapping program. Motions filed related to the subject will likely be ruled upon without a hearing. So if you can't agree to a place, then you have to do it at a police station or sheriff's station. And if you file a motion, the court is just going to tell you where to exchange your kid or your kids without a hearing. So as soon as you file the motion, they're probably a day or two later, they're going to issue an order and they're going to say, okay, exchange your kids here. Remember, it's always better to reach a resolution to issues in your case yourself rather than to be told by a judge what you are going to do. Control your own destiny. Don't put it in the hands of a judge. All right, if shelter in place order is issued by the governor or any other government officials, and regular time sharing can occur and be consistent with the governmental orders, and regular time sharing shall continue as ordered by the court if necessary as further described above. If you cannot facilitate the time sharing in accordance with the orders, the parent, this is how it's different than Miami-Dade County. The parent with the majority of time sharing, which is 183 nights per year, shall keep the children until the governmental order is lifted or a court order is entered. Parents should assume that any parent losing time because of measures taken for the COVID-19 will receive make-up time sharing, and that the court will sanction behavior that it deems unreasonable. There's that word, unreasonable again. And unreasonable is a tricky word, because what appears to be completely reasonable to you can be completely unreasonable to a judge. This is where it gets dangerous. This is where you need the help of a family law lawyer in determining what is reasonable, because we know what is reasonable because we've done a bunch of these cases and we see what judges think are reasonable. So remember, your definition of reasonable may not coincide with a judge's definition of reasonable. Keep that in mind, because I think if you take advantage, or any party takes advantage of this situation and acts unreasonably, the court's going to hammer them. And you can file, doesn't bar any party from filing a motion with the court in the interim. And let me tell you, they're not going to want to see these motions. They're not going to be happy to see these motions. And if you're found to be unreasonable, you're going to get a very bad result. All right, as far as communication with the children, it should continue to take place and should be regular and consistent. Should increase to regular and consistent contact to alleviate fears and concerns of the children that the children may be experiencing. So there you have it, Dade and Broward County. So what is the importance of these articles or these orders, and what do we get out of these orders? Number one, be reasonable. Number two, just as important as number one, is make sure you communicate. Go to extraordinary levels to communicate and extraordinary levels to reach agreement in issues that pop up at this time. Although the court is going to entertain motions, and they are going to start setting motions for hearings, either electronically or telephonically, you probably don't want those types of motions before the court, where the court has the opportunity to make a finding whether you're reasonable or not. Keep in mind that your definition of reasonable and somebody else's definition of reasonable and the judge's definition of reasonable may be entirely different. If there's ever a time where you've tried to work things out, this is the time to go above and beyond for both parties. Not just one party, not one party giving in completely, but both parties. It is important to work together. Work together at this time for the benefit of your children. You know, your children, they may be small, they may be, little kids. You think of them as little kids, but children are smart. They hear things, they form opinions, whether they're true or not. They form fears, whether they're founded or not. This is not the time to make it worse for them. Make it better for them. Think of your children as a priority and overlook whatever other emotions that you have in this case is related to the other party. That's just my advice. That's advice I give clients all the time in all cases. These are extraordinary times. We will get through this. We are all in this together, and it will move forward. The good news is, as the courts seem to be becoming more and more adapted to the online scheduling or the online remote conferencing, and that will enable us to move cases along through the court system, maybe even more efficiently than it was before. See, before we had these hearings, like say you have a 5-minute motion calendar, now we can sit around on Zoom, we can continue to work, and whenever the judge is ready for us, the Zoom will pop up and we'll get a notification, we'll do the hearing, and that's it. 5-minute motion calendar before was, you got to drive down to the courthouse. You got to sit there with maybe 50 other people who have 5-minute motion calendar at the same time and wait your time in line. Before, 5-minute motion calendar could take 2 hours. Now it can take just a few minutes. Not only does that save you money, it makes the court process more efficient, and it makes your case move along faster. Anyway, I will post both of these orders, links to both of the orders in the comments or the descriptions below, depending upon what platform you're seeing this video on. They will be available to you. Certainly, if you have any questions, feel free to ask. You can either DM me on any of the platforms. On Facebook, I have a private group, Ask a Florida Divorce Lawyer. If you join that group, you can post questions in that group or message me through Facebook. I also have a Facebook business page, the Law Offices of Patrick McGeehan. You can catch me on LinkedIn at Patrick McGeehan. You can catch me on Twitter at PJ McGeehan Law, and Instagram, Snapchat, Tumblr, TikTok as the Magic City Lawyer, or you can email me directly, patrick@pjmlawyer.com. So if you have any questions, do not hesitate to reach out and ask, and I will answer them as best I can. I only practice in Florida, so I only know about Florida. So if you're in another state, I won't be able to help you. But keep in mind, these are extraordinary times. Move cautiously. Number one, move reasonably and communicate. And probably the most important thing I can tell you is document. Document, document, document. Have all communications, if you're self-represented, have all communications through email or text message or one of the parenting apps, so you can support your position if the judge ever has a hearing. But remember, don't give the judge an opportunity to rule through your conduct, an opportunity to rule whether or not you're reasonable. If you have any questions, you better be dead set that you're reasonable and dead sure that you're reasonable. Because if the judge finds you're unreasonable and you're taking advantage of this situation, they're going to hammer you. Be careful. Remember, we're all in this together. We'll get through it. This time next year, hopefully we'll look back and we'll all say, man, that sucked, but we made it and now we're stronger through it. Anyway, that's all I have for today. Tomorrow will be another topic. I already have the topic picked out and outlined, and I don't know when I'll get that video up. And then remember, we'll have Monday Lives on YouTube and Facebook and TikTok, and then we'll have our weekly Wednesday Law and Life Live at 6 p.m. Next Wednesday at 6 p.m. Every Wednesday at 6 p.m. that I can make it in there, I will. See you then. Good luck, and everybody stay safe and stay healthy.